Hi, y'all, and welcome to tonight's live stream. Well, in the ongoing saga between Blake Lively and Justin Baldoni, Blake Lively is doing everything in her power to, as she puts it, keep documents falling into the wrong hands. She says there are 100 million reasons why Baldoni's side might try to leak text messages and other information. That's how much PR value that they have, she told a court yesterday at a hearing. This was in the suit between Blake Lively and Justin Baldoni. Now, Blake Lively has sued Justin Baldoni for harassment and retaliation. He sued back for tortious interference with contract and a host of other claims on both sides. Now, who is it who wrote these super high value text messages? Well, technically, the hearing was about Justin Baldoni and Blake Lively. But underneath that surface story, in a lot of ways, this hearing was really about Taylor Swift and some of Blake Lively's co-stars like Jenny Slate or Isabella Ferrer. They are the ones who would be protected. That's not obvious on the surface. This is one of those legal issues where there's just a lot bubbling underneath the surface of what you see. And unless you know kind of the inside scoop of how the legal process works, you're going to miss that. You won't understand it. So I want to take a look at three things tonight. First of all, I want to look at the fact that Blake Lively is moving for a really broad, unusually broad protective order. And we'll talk about what's so broad about it, and why would she want to do that? Why would she want so much to have a broad protective order? What even is a protective order? We'll cover all of that. What this argument is really about is the next thing we're going to talk about, like what's going on underneath the surface, because this argument is not what it seems on the surface. It's really about things that you aren't seeing and you aren't hearing. And then the third thing is I want to talk about how the judge reacted. It didn't sound like he was in favor of the request, but we don't really have an answer yet. So super shout out to the first five in our chat tonight: Angel, LaFawn, Loretta Powell, Francesca's Orchid, Shiro Sheena, and Liz Peaceful. Glad to have all of you. And let us dive in. Now, the two sides are negotiating over a protective order. A protective order is an order from the court that says everybody is going to keep certain matters private. So the idea is we let discovery go ahead and start. That's where the two sides start exchanging information that they know about whatever the topic is, whatever the lawsuit is about. And so the protective order would keep everything private, or at least certain things that are designated. So the presumption is when you exchange documents or text messages, whatever they might be, it's all going to be public, unless there's a protective order. And if there's a protective order and people say I want this particular document under the protective order, then that particular document is going to be kept confidential. There are rules within the protective order that say what can be done with the document, who can see it, and that kind of thing. So this is really common in civil litigation. And unfortunately, it is often misused as well. In a lot of cases, one or the other party will hide behind a protective order. I'll talk a little bit about that, kind of explain how these get misused. But they are not unusual. And in fact, they are so usual that this court, who is hearing the Blake Lively, Justin Baldoni case, this court has a standard one that just, here, you need a protective order, here you go, everybody just sign on. And I've already entered this one 1,000 times. I'll be glad to enter it again for you. That's how standard it is that this be in especially big civil cases. So where they have a lot of money is at stake, where some kind of private interests are at stake, a lot of times people will have a protective order. So Blake Lively doesn't like the standard court order. That isn't strong enough in her opinion. She wants more. She wants a broader protective order. So I wanted to show you what it is that she wants. Let's start. I want to add to the stage and show you what the court's protective order is, and then we'll compare it to what she wants. So give me just a second to get that up on the screen. So this is the protective order that would normally be entered by the court. And it said the person producing any given discovery material or that person's counsel may designate such material as confidential in whole or in part only if counsel determines, and I put these in special colors because I want to mention them to you. They're really important. Only if counsel determines reasonably and in good faith that such designation is necessary to, and we'll go over this in a little more detail, to protect the interests of the client in information that is proprietary, a trade secret, or otherwise sensitive and non-public financial or business information that is of a personal or intimate nature regarding any individual, or that is subject to a contractual or other duty of confidentiality owed by the client to a third party. Now, I've given you a break. This is how long it is, right? So what I've done is just kind of focus in on what really matters for purposes of this. So what really matters is that when a person when a court enters a protective order, it's not supposed to cover every single document. The parties are supposed to use it carefully, only for those documents that really need it, or depositions that really need it, and usually only for parts of a deposition that really need it. If somebody is deposed for 200 pages worth of transcript, most of that's not going to be confidential. Only a few pages will be. So it's supposed to be the lawyer looks at it and makes a decision and says, well, reasonably in good faith, I think it's necessary to put this part under protective order. And some of the reasons that the court allows are to protect the interests of the client in information that is proprietary. That means information that no one else knows, that's personal and owned by this particular person, or a trade secret, or sensitive, non-public financial or business information that's of a personal or intimate nature regarding any individual. So, and that's a separate one. Personal or intimate nature regarding an individual is separate. Or that's subject to a contractual or other duty of confidentiality owed by the client to a third party. So those things, breaking those out, what the court is looking for, what the court expects is only when something is unusual. It's not just everything somebody says or every document that gets produced in a case. It's the things that are personal, that are intimate, that are trade secrets, that are owned by somebody that really would make a difference if they got published and got out. And so that's what the court is expecting to be covered by a protective order. Well, let's take a look then, because that is standard. That's the kind of thing that you would normally find in a protective order in a civil case, but that is not what Blake Lively is wanting. Before we get to some of the specifics about what she wants, I want to give just a couple of reasons why, in general, these protective orders can be a real problem just in general. You have to understand just how extreme what Blake Lively is requesting is. And in order to understand that, you have to kind of know where some of these can go. So like I said, they're used frequently in bigger cases, but they have three general downsides, I think. The first is that they're often used for the wrong reason. They are used to hide information that the public really needs to know. I'll give you an example. Let's say there's a defective product and Sarah gets hurt. Sarah sues the product manufacturer. So there's discovery, and the product manufacturer produces a bunch of documents that show that the manufacturer knew perfectly well that this product was very dangerous. And in fact, it's so dangerous that other people have been hurt. It's more serious even maybe than Sarah first thought. But the protective order protects all of the information. All of the information is designated by the product manufacturer as confidential. So that means Sarah can't tell anybody about this. She can't go to the newspaper. If she hears of someone else being hurt, she can't tell them about it. Then the manufacturer settles Sarah's case. Everything remains under protective order. And the result is the public doesn't find out about how dangerous the product was. So everything was under seal. And that is just a really unhealthy product. So a second problem with them is that they tend to get overused. Lawyers tend to think everything should be confidential and secret. And with protective orders, bleed over then is just kind of a classic problem. So like I explained, everybody's supposed to be really careful. Not every document is confidential, not every deposition, but what happens in truth is it becomes kind of standard where one side will mark just about every document as every document confidential. In fact, in most of my civil cases where we had a protective order, that was the case. All documents got marked by the other side as confidential and under the protective order. It was rare that someone actually made sort of a thoughtful decision about what really ought to be under the protective order. But one or both parties will mark virtually every document as, protected. And that is often something that happens. And then the third thing is it can just become a real administrative hassle, both for the court to try to separate these documents and also for the lawyers, because every single time you file something, you have to file the exhibits under seal. You have to, maybe parts of your brief have to be blacked out or otherwise redacted so that people don't know about it. So that's context for you. That shows you in general, even the protective order the court had done would be subject to all of those things. It would be very possible to misuse that, to overclaim, to claim a lot of things that aren't really confidential, should be kept that way. But what Blake Lively wants is way, way more than that. And so that's why I need you to understand how broad what she's asking for is. So both sides agree that they want a protective order here, but she doesn't want that standard one. She wants special sections for attorneys' eyes only. They call it AEO in their proposed protective order that they sent into the court. Attorneys' eyes only means only the attorneys get to see this, not even the parties. That would mean that if Blake Lively produced text messages she had with anyone, then and they were marked as attorney's eyes only, well, that means Justin Baldoni can't see them. That means also the other defendants, because I think there are 10 who are named as defendants by Blake Lively, and Justin Baldoni's PR agents are also included as defendants. And so some of them also, or all of them who are defendants, would not be able to see these documents. So it's not just about public access. And in fact, it's really not about public access. The judge's protective order already covered anything of a personal and intimate nature regarding any individual. So that was already there. And remember what I mentioned about that protective order creep, I'll call it, where more and more stuff gets shoved under there. That's going to be used to keep a lot of things under seal that really shouldn't be and that aren't personal and intimate, at least in many cases. That's how it would end up working. So what Blake Lively wants is not about the publish. It's about way more than that. And let's take a look at what she specifically asked for. So this is her letter brief where she told the court, this is what I want. And she said the proposed protective order, that means the one she wants, differs from this court's model protective order primarily by adding the following: an attorney's eyes only category, which applies to confidential discovery material of such a highly confidential and personal, sensitive, or proprietary nature that the revelation of such is likely to cause a competitive, business, commercial, financial, personal, or privacy injury. Specific examples of categories of discovery material that may qualify as confidential or AEO discovery information in a case of this nature, including, for example, previously non-disclosed information unique to the entertainment industry. And I want to stop for a minute. Think about what information unique to the entertainment industry could be. Let's say Blake Lively and somebody are talking just about their next, a show they did together, or a movie they were in, or anything related to that. That arguably could be non-disclosed information unique to the entertainment industry because that's their business. That's exactly what they do. And it also includes information of a personal or intimate nature in a case involving high-profile individuals. Put a huge circle around high-profile individuals, because you'll see as we go into it, that is very much what this protective order is about. And allegations of SH, a limitation on who can receive materials designated as AEO, and an emphasis on the restriction on publicizing discovery material. So those are the things that would expand it. Blake Lively's team also said, as detailed in her amended complaint, Ms. Lively, her family, other members of the cast Various fact witnesses and individuals that have spoken out publicly in support of Miss Lively have received violent, profane, sexist, and threatening communications. And so she's saying there's a reason for this, that people are being threatened, people are concerned, and they need protection. That's her argument. Additionally, the Lively case rests on allegations that the Wayfarer plaintiffs launched and continued a retaliatory smear campaign in order to destroy and bury Miss Lively, funded by a defendant who committed $100 million. Courts must consider privacy interests of innocent third parties as well as those of defendants that may be harmed by disclosure. So let's take a look at specifically the red line that she offered. And I've marked certain parts of this that I want to show you. You can see any part that's in red is a part that used to be there in the court's model order. And then the blue is parts that have been added. Now, some of that, obviously adding the names of the parties, that's pretty standard. But you'll see as we get into it that there's a lot of blue where they've added, and also there's some red where they've removed parts. And these are changes that Blake Lively wants to make to the judge's order. So let's take a look at what some of them are. So here's the most important part, the attorney's eyes only section. And it talks about giving that designation to the confidential discovery, the things that I just read to you, that would and it says it's only supposed to be used for things that are of such a highly confident and personal, sensitive, or proprietary nature that the revelation of such is likely to cause a competitive, business, commercial, financial, or privacy injury to the producing party. But notice that's really broad. It's personal, it's sensitive, proprietary. It could cause any kind of injury, basically, any injury at all. That's what they want to cover. And they're saying that we want to cover everything copied from it. We want, if somebody talks about it in a deposition, you need to make that separate. And it's important to remember, and notice through here where they've added the section, and it's a little hard to tell it's blue, but I've highlighted it in yellow. So the person producing may designate. That means this isn't something from the court. The lawyer gets to decide completely on their own, I believe this is confidential, for attorney's eyes only. The lawyer gets to decide that. So Blake Lively's lawyer gets to decide this can't be shown to Justin Baldoni. It has to be that it will cause harm to, and it's also enough that it cause harm to a third party, quote, including high-profile individuals to whom a duty of confidentiality is owed. And those high-profile individuals, you will see that gets added in throughout. Let's see if I can find another spot where I can show you. All down in here, number 10, you see high-profile individual gets added in over and over again because that is what I think what this is really truly about, is these high-profile third parties who would be pulled into this. And that would include a lot of people Blake Lively wants to testify on her behalf, co-stars. It would also include, according to the Daily Mail, there's already been a subpoena, or definitely will be a subpoena issued to Taylor Swift. She's a close friend of Blake Lively's. And it's not just that she's a close friend and so she might have heard things. It's also that she was present at a meeting between Justin Baldoni and Blake Lively and Ryan Reynolds, and that she had comments about work Blake Lively had done to change part of the script. That is one of the disputes in the case, is this script change that Blake Lively did. And Justin Baldoni says she came in and she tried to take over everything and she did a terrible job. And Blake Lively says, I rewrote this and it's better. And I know it's better because Taylor Swift and Ryan Reynolds agreed with me. They both thought it was really great. So those are the kinds of communications and so forth that they would want protected. Now, not specifically anything probably where Justin Baldoni was present. That wouldn't make a lot of sense. But if Taylor Swift was present for that, then she probably also had discussions about it. And those sorts of things might well be put in this for attorney's eyes only section. And you look down here, it includes non-public information regarding the identity and nature of personal relationships. Like that's huge, right? The identity and nature of personal relationships is really vague. I mean, the identity of a relationship would be like, I'm friends with Jane, or, I go to the, what would be what would be a good example? I go to the chiropractor, and the chiropractor's name is Ed, and those sorts of things would be non-public information about a personal relationship. And all of that something even as mundane as that might be included in this. It's pretty broad. It also talks about medical, mental health, and or healthcare records. And that came up again specifically at the hearing. It was apparently something of significant concern to the Blake Lively side. There must be something they're concerned about because they brought that up. One of the things that we don't want produced is anything related to medical, mental health, or healthcare. But if it has to be produced, then what we don't want is for that to be disclosed to anyone, including the parties in the case. We'll do another video on why there's not going to really be a choice. There is going to be mental health information that's going to get produced. We'll cover that, but legally speaking, there's not going to be a choice on that because of what the allegations are and because of the claims for damages in this case. All right, so with respect to discovery materials designated as attorney's eyes only, such material shall only be disclosed to those persons identified in, and it names a bunch of paragraphs, but shall not be disclosed to the parties. That is really difficult to maintain because when you work with a client on a case, you're working on, they help you prepare for the case. You meet with them and you say, okay, here are these. What do you think about that? Tell me why this is wrong. Tell me why you don't believe that. Tell me what our response to this is. If none of these can be shown to the parties, it's very difficult for the lawyers to prepare because they don't really understand it. They don't have the background and knowledge. You are constantly talking to your client about all of those things that you don't know. Because as a lawyer, I want to know what my client knows, but I can't possibly do that without talking to my client about these things. That's really a difficult proposition. One time ever did I have an order entered where the client couldn't see certain things, and it was extremely limited. It wasn't something where the attorney got to just select and then inform me what it would be. There was a specific decision that this small group of things would not be allowed to be shown to the clients, and that was it. You also look down at number 9. It's changed to number 9, used to be number 8. And it's kind of flipped the way this would work. Normally, the judge does have a provision that if there's going to be an objection, if somebody says this is all confidential, and so all of this is going to be confidential, and I'm going to make sure I'm going to put it under that. I'm going to put the designation under it that's confidential. And the other side objects, then the person who wants it confidential goes to the court and complains about that and says, okay, look, this should be confidential. They don't want it to be. But this flips it around. Everything is marked. If they mark it as attorney's eyes only on the Lively side, then it's up to Justin Baldoni to take that to the court. And so it's up to Justin Baldoni to convince the court otherwise. So it swaps the burden of dealing with an argument over this. And let's look specifically at this paragraph. A party may be requested to produce discovery material that is subject to contractual or other obligations of confidentiality owed to a third party or high-profile individual, and that gets added. Within 2 business days of receiving the request, the receiving party subject to such obligation shall inform the third party or high-profile individual of the request, and that the third party or high-profile individual may seek a protective order or other relief from this court. So the way that would normally work is if you need documents, say, from a third party, and those documents the third party might object to them, then the third party can go to the court and ask for a protective order. But they're saying we don't want it to just be for confidentiality where we agree that we owe a duty of confidentiality to this third person. We also want this to be for high profile individuals. So before anybody requests anything from them, we have to tell them what it is and give them the chance to come to the court. What that would mean is there would have to be some kind of notice given to, say, Taylor Swift. And Taylor Swift would be able to say, no, I'm bringing my, battalion of great lawyers from New York City, all at $3,000 an hour. And the entire battalion will show up and argue that Taylor Swift shouldn't have to produce anything. And most importantly, should not have to sit for a deposition. And I guarantee you that will be an argument that gets made. So it's just but they're adding not just where there's an obligation of confidentiality, but for any high profile individual. And there's not really a definition of that that's provided by the court. This is just, hey, if we think this person is high profile, then they get treated specially. So that is kind of calculated to drive the court crazy. I'm going to pull that. I think I finished with that. So I'm going to pull that out. So because it clearly separates certain people. Some people are treated specially. The high profile individual gets treated specially in a way that normally would not be done within a lawsuit. And so that is already something unique and different that they're attempting to do. Definitely not showing this information to the parties is really just unusual and would make, frankly, a very difficult time for the parties as they try to respond. Now, let me show you, it won't shock you to learn that Justin Baldoni did not agree with this. And here's what he said. He said, well, first of all, you have publicized this all over the place. You started this whole thing, he says, by going to the New York Times. So it's not like you've kept everything confidential except what you want confidential. And says, Ms. Lively's counsel and spokesperson routinely attempt to rehabilitate her tarnished image with bold statements to the press, or trying to convince the press that her amended complaint saves her meritless claims by referencing other purported victims, although she fails to name a single one. Now, what that's about is that there was an amended complaint filed by Blake Lively where she said, okay, here are going to be all the claims I'm going to bring against Justin Baldoni and against other defendants. And in that, she mentioned several times, do I have that? Yeah, I've got that. I can show you. So here's what she said in that. She says, for example, let's go down to, we'll do, I think I have paragraphs 5, 6, and 7. When faced with the predictable consequences of having created a toxic set, namely that the cast did not want to appear alongside him in public, rather than holding himself accountable, Mr. Baldoni hid behind his billionaire friend and retained publicists, crisis managers, digital media strategists, and litigators to mount a sophisticated and well-funded retaliation campaign that sought to bury and destroy anyone that challenged his brand. That campaign has succeeded beyond Mr. Baldoni's wildest expectations. In fact, the defendant's actions have created such a toxic climate of online vitriol against Ms. Lively, her family, other members of the cast, and various fact witnesses that all of the above have received disturbing threats. One fact witness, known to publicly support Ms. Lively, recently received a written threat indicating that the witness's family would be sexually assaulted and killed unless the witness agreed to make a statement and give the truth. So those sorts of claims weren't backed up by names. So there, it says there's a fact witness known to publicly support Ms. Lively, but there's no name, right? Just this person. And there it continued throughout, but I'll give you 2 more paragraphs to show you what I mean. The dangerous climate of threats, harassment, intimidation fueled by the defendant's retaliation campaign has required Ms. Lively to alter her personal and professional life and to take steps to protect innocent bystanders rather than exposing them to further harm. Thus, this amended complaint does not refer to certain witnesses by name, nor does it provide screenshots of their text messages. Importantly, however, these witnesses, remember, totally vague, have given Ms. Lively permission to share the substance of their communications in this amended complaint as contained herein, and they will testify and produce responsive documents in the discovery process. So what this whole protective order is really about is these witnesses, the people not being named. And Blake Lively doesn't want to name them. She wants that to be for attorneys' eyes only, and she wants it to be confidential so that the public never learns who the people supporting her are. That's really behind all of this, but not just the public. She doesn't want it to leak through any of the parties. So it's not so much probably that she cares that much that the parties know it, as that the parties, particularly she is concerned about the PR agents, might leak it. They might know how to leak it easily and without it being traced back to them. But Miss Lively was not the only one who was uncomfortable on set, and Mr. Baldoni and Wayfarer knew it. After Mr. Baldoni learned that he had caused Miss Lively and others to feel uncomfortable, he turned his TED Talk and feminist advocacy on its head. He did not hold himself and other men accountable or take his own advice to be confident enough to hold their anguish and actually believe them, but instead used a louder voice to silence Miss Lively and anyone else who might speak up. So again, what he's talking about there is that Justin Baldoni is saying that these people haven't been named. There's this argument by her that these people are going to testify, that they're going to testify in her behalf, but there's not actually the name of a person. There's none of that actually being made available. So he's suggesting maybe these people don't really exist. Maybe she's not naming them because she's just saying that. Then it will all go under seal, and I'll never be able to prove that there were no people who actually were these witnesses that she kept talking about. And he then made a little dig at the Saturday Night Live matter. Worst of all, in a planned skit on NBC's Saturday Night Live 50th anniversary special, which attracted almost 15 million viewers, Miss Lively's husband, Ryan Reynolds, stood up and made a joke about her claims for harassment and emotional distress. And so for those of you who didn't see it, Saturday Night Live was having an anniversary special, and Ryan Reynolds, Blake Lively went. They did a Q&A, and as part of the Q&A, Ryan Reynolds stood up and had a question. And they said, yes, what's your question? They said, oh, hello, Ryan Reynolds. How are you? And he said, great. Why? What have you heard? And I didn't even think it was very funny, but it certainly attracted a lot of attention. And people felt like he was trying to flip this on its head, trying to get really good PR out of this, and that it's all been a PR war. You're going to hear about the judge saying something pretty similar in just a minute. So, and he, continuing in the letter brief that was written by Justin Baldoni, he says, look, she's already given all these details. What is there to be secretive about? And then there was one last reply from the Lively side and said, look, we need this attorney's eyes only. And we need this because the model one doesn't talk about third parties, and it doesn't apply this process to third parties. Again, showing what this is really about is not what happens between Blake Lively and Justin Baldoni, but what happens with the stars like Taylor Swift and the other co-stars from It Ends With Us, the movie that Justin Baldoni and Blake Lively starred together in. And leaving aside the callous disregard and disrespect for a woman advocating for the most basic workplace protections against sexual harassment, continuing to read in the letter brief, the Wayfarer Party's position that a woman who speaks up against harassment, SH, I should say, has somehow waived any and all privacy interests shows the futility of future conferral. That means there's no reason for us to keep talking about this. They're never going to agree with us. These are simply terrible people. That's more or less the argument being made here. The inevitable byproduct of the Wayfarer Party's position will be a massive waste of party and judicial resources, as parties and potentially third parties seek to convince counsel for the wayfarer parties that women do not forfeit all of their privacy interests simply because they have spoken out or intend to speak out against the wayfarer parties. So let's talk a little bit about kind of what's going on there. First of all, it's one of the problems with the entire discussion that's being had by the Blake Lively side is that there is sort of the idea that the entire case, everything he's done was to oppress other people. And there seems to be a disconnect between the realization that this is a publicly filed lawsuit and taking advantage of the public courts and the public judicial system. All of those things carry accountability with them. The accountability includes the fact that a lot of things you say and do will become public because you are asking the court, paid for by the public, to come in and handle this dispute. You're saying that you couldn't do it. Then ultimately you will ask the judge and you will ask the jury to make decisions in your case. All of that is you asking the public to enter into your dispute. As part and parcel of that, things will happen that will make your lawsuit public. That is going to happen. And that's pretty much where things ended up with the court. So I want to talk just for a second about why it's so clear that it's about Taylor Swift and the other witnesses. First of all, there's that high profile individual that gets added. Secondly, it's really about the embarrassment that some of these other people might feel if they came forward to speak for Blake Lively, because public sentiment is clearly in favor of Justin Baldoni. I've cited the poll I saw done on Court TV, which was wildly in favor of Justin Baldoni. It was something like 96-4. And it's also about notifying these high profile individuals before anything has to be done, before they have to turn anything over. Obviously, they're going to know in advance before they have to turn over anything. I mean, they're not going to be surprised by a deposition where they wake up in the morning and people are sitting out there and they have to immediately move into a deposition. There's no surprise that there. But it's also about anything Blake Lively might have to produce. So let's say Blake Lively is asked for all your text messages with Taylor Swift for this 2-week period or whatever. Then Taylor Swift may want to argue against that as well as Blake Lively. So it adds additional people, additional arguments inside the context of this one lawsuit. And it's also about keeping the defendants from seeing anything about this. There are 10 different defendants, and some of those are PR specialists. And I can imagine with reason, there would be concern that these people do know how to disseminate information and maybe it wouldn't be able to be traced back to them. In fact, the judge said, Judge Lewis Lyman said, what's going on here is a feud between PR firms. And there's a lot of truth to that. It was pretty perceptive. Justin Baldoni's PR specialist is Melissa Nathan. She was working with Leslie Stone, and Melissa Nathan left to form her own company. She took the Wayfarer company, which is Justin Baldoni's company that he's part of to do the It Ends With Us movie, and Justin Baldoni, she took them as clients when she left Leslie Sloan. So she says that Leslie Sloan took information from her phone and turned it over to Blake Lively. Now, I don't know anything about the truth of that, but for sure, there's bad blood between them. And Baldoni has sued Leslie Sloan. She's a defendant in his case. And Blake Lively has sued Melissa Nathan. So they're involved. They're part and parcel of this case. And they may not be household names, but they are very powerful in their ability to reach the public. That's what they know how to do. And the PR firms want to protect their client list. That's one of the things that got discussed at the hearing. They don't want to tell each other, much less the rest of the industry, who their clients are. They want that confidential. But the judge and then Justin Baldoni's lawyer were saying, well, the name of your client may not, I mean, that probably isn't really a trade secret. That isn't something that's it's not confidential in the sense that it's some kind of process or trade secret that enables you to do your work. but we don't have a final ruling on any of this yet. We don't know where the judge will come out exactly. It didn't sound to me like he was headed toward a really restrictive protective order, but it is really important that the parties realize when they file and take advantage of a public forum like a court that there are consequences to that. Blake Lively filed the case first. There are consequences to that. Now she can't just get rid of this case. She can't just say, well, never mind, because there is now another suit by Justin Baldoni against her. So even if she dismissed her own case, she wouldn't be able to get rid of the other case. There was also discussion about whether or not Blake Lively and her team were trying to suggest or hint that maybe the Baldoni side was actually a threat, like in and of themselves, a threat. And pretty much the judge said, I just don't really see that being the case. And I don't think it is about that kind of threat. I think it's about releasing it to the public and then the public being a threat. There was discussion about profound health issues, and it wasn't clear what that meant, but there may be something that is important on the Blake Lively side that they want kept confidential related to health, but it wasn't really clear what that would be. We don't really know about that. The judge pointed out, look, even if people violate my order, I've got things I can do. I can hold people in contempt. It isn't like I'm just going to walk away and ignore that any of this happened. And of course, the Justin Baldoni side took offense that there was even a suggestion that they would ignore the court's order and said, of course, we will do with that. So that is pretty much what happened at the hearing this week. It was a very interesting hearing, particularly because it revealed so much about what was really going on with the parties, what really was driving them to have what was driving Blake Lively in particular to try to get this protective order that was so broad. What are the things she wants to protect? And it appears that the most important thing, the driving force for her, is the relationship with the high profile individual she mentioned. So I'll take a few questions. If you would put question marks at the beginning, that will help me spot them in the chat. And but let me say hello to Dolly, has been a member for 6 months and says thank you to me and to the mods. Thank you, Dolly, for being a member for 6 months. I really appreciate that. And as far as our mods, I am so appreciative to Marlon and to Mama Pinks and Denise Pelton. They do a great job, and I'm very appreciative to all 3 of them. And Liz M has been a member for 12 months and would like to mention this is the best YouTube community ever. I totally agree with that. I'm very fortunate to have y'all listening. Very grateful for that. 12 months, fantastic. Now, the membership it's a way of financially supporting the channel. Next week, we are going to be having a really fun event for members. It will be after our regularly scheduled live stream. We've got we go live Monday, Wednesday, and Friday at 7 p.m. Eastern. But after that, when we finish our regular live stream, we will have a special members only live stream. We are going to write the world's first, I'm convinced, YouTube community true crime novel. And we're going to use, it's going to be AI assisted. We're going to come up with our plot, and we're going to be figuring all this out. I think we'll do it over time with maybe 1 chapter a month or something. We have all kinds of things planned. And so I am really looking forward to that. If you're not a member, please join us. You can hit the join button down by the name Lawyer Lee right below this video. Or if you are on your iPhone, you can go in through Safari or your browser or use your regular computer. The iPhone doesn't have the join button. Okay, so let's take a look at what some of the questions are. Michael Lalonde says these cases are like wild roller coaster rides. That is certainly the case. This is a wild one, and it's going to continue to be. One of the questions, though, is how much will we get to see as members of the public? And if what we see so far is an indication, maybe not a lot, but I think people will be dropping things in to briefs that will be public, and that's part of what we will be finding out. Now, if it becomes for attorneys' eyes only, we may get heavily redacted briefs. We may get exhibits that are put under seal, and we may not get to see a lot, but we will find out. They've already put a lot into these. We have a ton to cover, even if they filed everything under seal from now on. It would still be a lot to cover. Okay, let's see. I'm looking for question marks at the beginning. Deaf Otter, have you ever watched a movie with Blake Lively? Honestly, no. Totally honestly, no. I really need to do that. I feel badly saying that. I'm not a huge movie person. My husband was a huge movie person, loved movies, could watch 10 a day. And I'm like, oh, I saw a movie last year. I don't really see a need to do that again, which is, I know, it drove him crazy too. Okay, Beth A., do you think that Blake Lively was blindsided about what discovery entails and who it can impact and is now freaking out? I think probably Taylor Swift is. And I think that it has to be impacting their relationship because they're good friends. As I understand it, Taylor Swift is the godmother of some or one anyway of Blake Lively's children. And so they're close, they're personal friends. And uh, Taylor Swift's image is squeaky clean. The last thing she wants to do is get yanked into a mess and end up with a problem like this. So I think that it could not have been totally clear to them what was happening. But I mean, and maybe the lawyers didn't even think to explain that in great detail. Maybe not. And once they started down the first filing in the civil rights department in California, maybe it just kind of couldn't stop from there. But I have a feeling that there was not a clear understanding of just how significant this was going to be. I don't think maybe even anyone could have predicted how big this was going to get, how much public attention it would draw. And it's been huge, how much of an impact it would have on everybody involved. So I think that now everybody's trying to damage control and more on the Blake Lively side, obviously, than on the Justin Baldoni side. Katie W. asks, and this is a good question. So they have this attorney's eyes only, then what about the jury? Why bother if the jury can't? Now, that's a great question. But actually, Katie, the way it would work is that it would be attorney's eyes only until it was presented at trial. There might be some kind of discussion in advance. For example, they might make the argument before the trial ever starts, Judge, we don't want the jury to see blah, blah, and blah because it will become public. And then maybe there'd be a little more talk and they might say, well, we don't mind if they see this, this, and this, but at least put it under seal. Don't let the public see it. Only the jury sees it. Almost like, crime scene photographs that might not be shown to the public, but would be shown to the jury. Now, truth be told, as far as the attorney's eyes only, it does not apply by the time the trial rolls around. It will, by the time trial actually starts, all of that should be set. The issues will have been hashed out. They'll have decided what's relevant, what comes in. They will have decided what the jury sees and what the jury doesn't see. But the jury, frankly, will see a lot of that. If it turns out it's relevant and it's important in the case, then the judge is going to let that in and the jury will see it, and probably the public will hear it as well. So it will have a purpose in the end, but not until the end. Kitty, if Blake went to HR and they resolved the issue or decided it was unfounded, would that affect her case? I'm guessing that it probably would not come in evidence, but I'm not positive about that. It depends kind of on what exactly the finding was. If HR wrote a memo and if HR is simply, it kind of depends on what exactly that is. If HR is a department within Wayfarer and they wrote a memo that said, wow, we believe everything Blake Lively said, now that would come in. And if they wrote a memo that said, nah, none of this seems right, we've looked at it and this was wrong and that was wrong, they would probably bring one of the witnesses to talk about that investigation. So if that's the way it worked, then I think whatever happened there will probably come in and probably will affect the case. As just a guess as to how that would play out. All right, Tila asking, aren't the texts important? Example, when Justin claims Taylor was present in a situation in this woman's home, as well as this woman's claims. So yes, the texts are super important. And in fact, if they weren't important, probably nobody would be fighting over them. But I think that one of the concerns for Blake Lively's side is not just the text messages that are directly relevant to what's happening here, but text messages that go broader, that talk about, well, I feel like, this seems a lot like that situation I had to deal with over here with this guy. He was terrible, and here's what I did. Just as an example, you could kind of see where that's a little bit related, but it's not really directly related exactly, but it certainly could be damaging if it leaked out. So those sorts of things are what they're worried about. Things that, even if they're relevant, might include other people, might include other facts, other issues that would then be damaging. Okay, so Mel asking, if I were Blake Lively's attorney, what kind of advice would you give her? She is in for the ride now. I would say buckle in, because you are now on the ride. I do hope she got good advice in advance about all the things that this was going to entail, because it's a lot. And so there is going to be extensive discovery. It's going to be public. It's already been brutal. It's already been extremely brutal, particularly for Blake Lively, but really for both sides, but really for Blake Lively. So the advice I would want to give would come beforehand, that this is all going to be happening. And now that she's in the middle of it, there's just a lot of hanging on and waiting. And I do think they need to hone their message that they're making public through this briefing. And it needs to be in tune with the general changing belief about this whole Me Too movement. It has to include public perception that is changing a little bit. They have to be prepared for that, and they have to address that. And from now on, their briefing needs to be doing that. I don't think they've done that up until now. And Jebby asking me, wouldn't this be detrimental to Justin Baldoni's rights? I'm not sure what you mean. Wouldn't what be detrimental, Jebby? Maybe you could put in a little something. You probably wrote that at a time with whatever I was talking about, and then I went on for a while. So if you wouldn't mind, I would appreciate your putting something else in. Lisa Shelton has been a member for 4 months and is heading to Atlanta. I'm so glad you watched and been a member for 4 months. That's fantastic. And safe travels. Safe travels. This is the weekend that Gibbs Gardens opens up. For those of you who've been around, you know that Gibbs Gardens is my happy place. And I can't wait. Very, very excited about seeing Gibbs Gardens again. So it'll be opening up starting this weekend. It'll be open until November, I think. So several months. All right. Well, I have enjoyed it. I will look forward to seeing y'all on Monday, double time, because we'll be doing our regular live stream at 7 p.m. Eastern. And then afterwards, we'll have the members only live stream. But I do want to say, there is so much Kohberger stuff, the Brian Kohberger case. It's just overwhelming how much new information came out. And are we going to cover it? Oh, yeah. Oh, yeah. We are definitely going to be covering it. So be sure to hit the subscribe button, hit the like button too. That will help the video get out to more people. But subscribe, because we would like to have you come back for more, and I will see you on Monday. There we go.